Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, a lecturer in ADR at the University of the West Indies, St. Augustine campus, and also the marketing liaison of on Wednesday, 2024 American Bar Association Dispute Resolution, and the host of Expert Views on ADR Ever video podcast show. I'm delighted to welcome Justice Dr Anthony Gafoor. He is the Chief Judge of the Tax Appeal Court of Trinidad and Tobago. Justice Dr Anthony is also the branch chair of the Chartered Institute of Arbitrators Caribbean branch and a certified mediator and arbitrator. He wears many hats. I've left the link in his profile. Welcome to the show. Let me start sharing that.
Thank you very much, Dr. Umegbolu. Pleasure to be here.
Oh, thank you so very much for honoring the invitation. So without further ado, the first question is, what is the history of appropriate dispute or alternative dispute resolution in Trinidad and Tobago? Thank you.
Well, I think that the developments in Trinidad and Tobago can be linked with developments throughout the Caribbean, in the sense that one of the main reasons why the use of alternative or appropriate dispute resolution, as you say, has become increasingly important is because they have been prompted by the procedural changes to the rules of the higher courts, the superior courts, and as a result of that, many, in fact, I would say virtually all Caribbean jurisdictions are now very much encouraged to facilitate parties in terms of giving them those opportunities to resolve the dispute themselves. And of course, this is primarily through mediation. But even before those processes took place, we did have various trainers who were targeting the region. The primary one, I would have to say, is the Chartered Institute of Arbitrators, but we've had several others as well that have been coming into the region, or we've had citizens from Trinidad and Tobago and elsewhere in the region, also availing themselves of both online and in-person courses in a variety of Commonwealth jurisdictions, particularly the UK and of course the United States and Canada, I would want to identify. And so as a result of that constant flow, if you like, of persons coming into the region, as well as persons who are involved in assisting others in resolving matters, whether they be lawyers or in other professions, there's been a very good hybridization, if you like, of those processes. And I think to that extent, it has probably contributed to the increasing popularity of this form of dispute resolution. Of course, we can't omit litigation, which still remains a primary basis for resolving disputes. But of course, I think increasingly we're seeing the greater and greater use of alternative, or I'm happy to adopt your phrase of appropriate dispute resolution in the region.
Yeah. Oh, thank you so very much, my lord. I wanted to ask, in Africa, we had this indigenous method of settling disputes. Was there something like that in Trinidad?
Yes, in fact, there is a long history of that in Trinidad and Tobago, because I can give as a primary example within, for example, the Eastern community, which communities are fairly numerous in certain jurisdictions, particularly Trinidad and Tobago, the Cooperative Republic of Guyana and Suriname, I can mention offhand. There was a long history of using a process to resolve disputes amicably through community intervention. Some called it the Panchayat system. It still exists, in fact, in India, where it would have originated. But I think the general idea is like Ubuntu and other jurisdictions. You have, in South Africa, for example, you have the idea of 5 village elders traditionally, drawn from various walks of life, who would be there to assist disputants. I mean, of course, the idea is that um, many of these communities didn't necessarily have access to the court system, and so there was an impetus to use the system. But I think in many ways, if I may say so, Dr. Egbunuke, one of the issues is that it was probably more effective than court orders, because one of the outcomes, and I'm not sure what the African experience in this regard, although I have studied it, is that there can be the ostracization from a community, and that in itself can be far more effective than the imposition
it's
of
the
a
same in
fine.
Africa as well. Yeah.
So I think many people were very anxious to ensure that they could resolve their disputes that way,
Right.
rather than having to go through, where possible, the court system.
Yeah. Well, thank you so very much. Yeah, in Africa, that they're so like sort of scared of what the chief would do if they tell a lie against their fellow human being when it comes to traditional method of settling disputes. So once they are there, it's sort of they reveal their true self, sort of they say the truth there, because they know what the outcome would be if they lie. So yeah, you're right.
Exactly. In fact, one of our former distinguished history professors from the University of the West Indies, Professor Rinzi Samaru, had pointed out, I think he's on record as saying that some of the consequences of being found culpable by this body, the panchayat body, would be to the fact that you could not attend social occasions. Neighbors were apparently entitled to come and take your cattle or or other animals, and really, apparently, in those days, many years ago, there was a water truck that would pass through the community, and they would be told to bypass your house, and there could be all sorts of issues arising from that. I'm not sure if one had these similar traditions here within the African community in the Caribbean. But I do know for sure that within the East Indian community you would have that. But undoubtedly there would have been emanations from what would have been practiced in parts of Africa as well. I'm sure that would have been brought in by through slavery, unfortunately, and other forms of other communities. I know the Chinese, for example, and the Syrian community, because we are a very multicultural society in Trinidad and Tobago, have all had their versions of what I've described, with reference to the East Indian community.
Oh, okay. Thank you so very much. It's so similar to that of Nigeria in Africa. Some of the African countries or continents we had, and it still does function till date. It's just that it's sort of modified because the Igwe, that's the king, and most of them are quite very well educated now, so it's not that barbaric, or as it were in some instance or in some cases. So it's still very alive and functioning in Nigeria, and particularly the eastern part of the country. Okay, so I could have asked you this question before the history, but it's just for you to sort of simplify what ADR is. And, to the best of your knowledge, has it enhanced access to justice in TNT? Thank you.
I would say that it has been a very helpful means of resolving disputes, not only because it's encouraged by the judicial system, but also because I think people naturally, would like to resolve their conflicts. I mean, of course, some people are very insistent upon having their proverbial day in court, and of course, they shouldn't be denied that. But what we're seeing is that increasingly within the Caribbean, it's taking its approach from what is practiced elsewhere in the Commonwealth, whereby the refusal to go to utilize mediation, for example, or other forms of dispute resolution may result in adverse cost orders, as well as, of course, leading to major delays in terms of having your matters dealt with and resolved. And I mean, ultimately, I would suggest that no one really wants to necessarily have their matters prolonged. I mean, they may be anxious to go to court, as I've suggested, but at the end of the day, all court systems are laboring under massive caseloads, and as a result, the ability to have your matter resolved as amicably and as quickly as you would through appropriate dispute resolution, I think can be quite staggering and so on. The number of years that can be tied up. And, to me, it's like the proverbial sword of Damocles that this thing is hanging over your head.
Yeah.
And really, it's very difficult to focus on other matters. And I think this is part of the challenge and is also part of the incentive to use, as you say, appropriate dispute resolution to try to resolve your disputes.
Well, thank you so very much, my lord. I also want to add that the period I interviewed some parties, and even that was in 2021, 2022, and in recent years, as the parties, the users of ADR were of the view that if they had known that this was in existence, that is ADR, they would have, gone straight to mediate or, arbitrate. But most times they don't know, and sometimes you find that the lawyers are not quite encouraging as well, so they don't tell them.
Yes.
So they don't know. But if the court now referred them, most of them were referred by the court, and they were like, oh, if we had known that, we would have approached the multi-law court center or gone to ADR, straight up, than going to the court and the court referring us. It saves time, and that's what they want. Like you said, most of them want to settle in little or no time. So yeah, thank you so very much.
What I want to add in that regard is that Trinidad and Tobago is one of the first jurisdictions in the Caribbean, and might actually be the first, to have brought in a statutory provision called the Mediation Act. Back in 2004, and in many ways that preceded the reform of the civil procedure rules with regard to the resolution of civil disputes. So that, I think, had a very useful function. I had the privilege to sit on a body called the Mediation Board of Trinidad and Tobago for many years, and our remit was to ensure that the provisions of the legislation were utilized and so on. And one of those provisions specifies certain courts as being mediation agencies, statutory mediation agencies. They would include my court, the tax-free court, but would also include, for example, the other emanations of the judiciary, and even the industrial court, for example, which is whose jurisdiction it is to resolve labor disputes, were designated as such. And I think that in itself emphasizes how important it is that the court system works together with ADR in helping parties to resolve their disputes.
Oh, thank you so very much for pointing that out. So what has been sort of the effectiveness and challenges in implementing ADR in PNT?
Well, I mean, if I look at other forms of dispute resolution, for example, arbitration, as you mentioned, I have the privilege at present of being the chair of the Chartered Institute of Arbitrators, which is a UK-based body, but of course having a branch in the Caribbean and throughout the world. One of the issues there is that parties may sometimes elect an arbitration for energy disputes. So we've seen several oil and gas disputes, for example, being resolved by other entities such as the London Court of International Arbitration and the International Chamber of Commerce and so on. But one of the things that I've been trying to do, and of course I say this together with my other colleagues, is to encourage the greater use of arbitration and indeed mediation and other forms of dispute resolution within the Commonwealth Caribbean, because we feel that we now have a fairly well-established and very experienced cadre of persons who may be able to assist. And one of the virtues of doing that is that you may have a greater appreciation of cultural nuances, like litigation. While we understand that many Caribbean jurisdictions still look to the Judicial Committee of the Privy Council as the ultimate court of appeal, I think it has generally been recognized even by the lordships in the UK as well as elsewhere that there are sometimes quite a diverse cultural appreciation of how things operate in the Caribbean, and that may well apply to other parts of the Commonwealth as well. So I think while we have a ultimate regional Supreme Court here, the Caribbean Court of Justice, we also understand that for many people who have an issue both in civil and criminal matters, the magistrates or the district courts, as I think they're more better known now as, would be the first interaction that somebody would be likely to have with the judicial system. And I think that that there has been an approach to try to enhance that, and of course, in enhancing that, also to facilitate and encourage the greater use of mediation as well. So while I think that arbitration, for example, has been used quite extensively in commercial disputes overseas and, of course, even within the Caribbean, mediation, I would suggest, remains the most popular form of ADR. And of course, it's much less costly in many instances than other forms of ADR. And of course, that means that the parties are entirely in control of the process, unlike arbitration litigation, where that decision making is handed over to the third party. In the case of arbitration, a private judge. In the case of the judicial system, it would be a state-appointed judge. And to that extent, sorry, when I say state-appointed, of course, there's a process whereby there's a Judicial Legal Service Commission, which is independent of the state. But the point is that, I think all of these mechanisms are really, I think, increasingly becoming popular with potential litigants, if only because they might help you to resolve matters. And I think one of the things that has to be said, and this is broadly true, as you would know, of ADR, is the preservation of relationships, because that may not necessarily be an outcome if you go to court or if you go to arbitration. But if you go to mediation, I've seen many, I've been involved in many where, parties end up shaking hands at the end, where there had been a loggerheads, there had been a lack of communication even over several years. And, so the marvels, or as a colleague of mine calls it, the magic of mediation is really something that I think we would want to continue to encourage and to foster, as much as we can.
Thank you so very much, my God, for highlighting those advantages associated with ADR. Especially the preservation of relationship, because that's one thing litigation does not offer. Once you go to court, you are done with.
it's an issue. It's an issue, and you see the thing with a court decision, as you would know, Dr. Ebunike, is that there's going to be a winner and a loser. Unless you're able to come up with a consent order whereby parties are able to still arrive at an arrangement which may be suitable for both parties. In many instances, if a judge or the decision maker has to take a decision, obviously there is going to be one party that's going to be successful, or possibly more successful than the other one. And that is likely to continue to fuel the dispute in the future, as opposed to getting them to agree that maybe sitting down and talking things through may be the better way forward.
Well, thank you so very much, my love. So what are the current laws and regulations surrounding ADR in TNT?
Well, the main piece of primary legislation, I would say, is the Mediation Act of Trinidad and Tobago, and as previously mentioned, it came into being in 2004. So we now have a 20-year track record of that legislation. And, in some ways, it can still be a bit of a hard sell. People, as I mentioned, like to have their day in court. But I think that the message is getting through slowly but surely that, there may be a better way to resolve disputes. Apart from that, we've seen major reforms in the civil proceedings rules. Those go back to approximately 2005. When, so again, we now have a fairly good, almost 20-year track record of those reforms. And those specifically make reference, as they do in the UK and other common law, Commonwealth jurisdictions, to the use of mediation as a form of dispute resolution. So I think it's incumbent on the courts not only to ensure that we can have appropriately rostered mediators or other dispute resolvers to assist in that process, but to refer parties. And I'm aware that, for example, many years ago in the UK, which still, of course, exhibits, and exercises a lot of influence on Caribbean jurisdictions, the bar rules there actually encourage and may even penalize lawyers who do not refer clients to mediation as a first step. And I think, if you go to, as a client or potential client, you go to a lawyer's office and, you clearly bring the issue that may be causing you some stress or dispute that you may have to their attention. One of the things that I think they need to do before, for example, pre-action protocol letters or other such documents are issued is to encourage parties to consider talking to each other, if possible, in the presence of a third party being the mediator. And I think that in itself can be helpful. And, very often I've seen it many instances where people enter the mediation room with a bit of a sour face because clearly they're not necessarily keen to speak to their opposite number with whom they may have a long-running dispute. It could be something like a boundary dispute, which can cause enormous stress between neighbors, or it could be proceedings for debt, relief and so on, or debt claim that loan may be outstanding, or things along those lines. And very often there may be a history of a relationship, often a positive relationship between the disputants. And I think that is where mediation ADR generally can play a vital role, especially within a smaller society such as Trinidad and Tobago and other Caribbean jurisdictions. I mean, our population is approximately 1.4 million. And of course, it's fairly populous. You have a lot of commercial transactions going on within the business community and between the business community and overseas suppliers, for example. And very often in those scenarios, you can have major disputes arising. And clearly, if you have a better means of resolving it, so you preserve that business or even domestic relationship, within a family context. I think that is obviously going to work to the benefit of all concerned, as opposed to, remaining at loggerheads and possibly even, discontinuing communications and so on. So I think particularly for smaller societies, the use of ADR is absolutely critical.
Thank you so very much for your insights. We have 8 minutes to go. So I want to quickly ask about whether employees are aware that they can utilize ADR in the rise of any disputes or conflicts at their workplace or with their employers or with HR or anyone. Can they utilize ADR in certain matters?
Well, I think, the answer is that it depends on the contractual arrangements. You have some employees who may not have a formal contract, and so therefore, the process is very much at large in terms of the possibility of an ad hoc means of resolving disputes. But you do have increasingly, I would say, employees' contracts, which may specify the use of some form of dispute resolution to resolve conflicts, among employees or between an employee and their supervisor, or, even with the company. So, for example, you've had instances of intellectual property disputes arising in that context. And one of the key issues there is the extent to which an employee who may have developed a patent or other, means of, being quite creative. So whether you're using your employer's resources to do that, and therefore whether the employer has a claim to, a patent or so. But there may be other instances, for example, where you simply have a disagreement with your supervisor. Maybe you've had an annual report that you're not too happy with the comments that were made therein. And of course, you may want to take it further. And I think that it's incumbent upon employers, whether in the private or the public sector, to ensure that employees are given the opportunity to, resolve disputes amicably through ADR. The extent to which that perhaps needs some attention is important. But for example, the Industrial Court of Trinidad and Tobago offers conciliation, which is in many ways very similar to mediation.
Yeah.
And so, for example, there's initial approach through the Ministry of Labour, if that becomes necessary. And then when the matters are referred on to the industrial court, very often the judges there may encourage the greater use of that. Similarly with my own court and other high courts and so on, we see that parties are often given an ample opportunity to resolve their disputes amicably, whether it's an employee or somebody else has another status or so. The court generally exercises a supervisory jurisdiction when parties try to engage in discussions, and if necessary can appoint a third-party mediator to assist them and so on. And it's interesting because if you look at the developments in the Caribbean, as I mentioned, we're a small society, so you may well know of people who are in that sphere. But this is something, for example, which, as you may know, is encouraged in the Far East. Places like Singapore and Malaysia and Hong Kong. I would suggest that parties actually welcome a mediator with whom they are familiar. And, as opposed to the traditional approach of somebody who may not necessarily know the parties themselves and so on. So, again, when I mentioned cultural nuances, I think these are important considerations. You've got to know your society in many ways. And we can't assume, of course, that all Caribbean countries are the same. I mean, we may have a similar historical background, but ultimately there are important cultural nuances, and it's always a matter of great humor when we compare the approach that somebody in Barbados might take to what somebody in Trinidad or somebody in Jamaica, and of course elsewhere in the Caribbean as well. And I think we appreciate, and indeed I think it's great fun, when we look at those differences. But there are some differences there. And I think the other point that is worth mentioning is that many of these societies are in flux. So we've seen, for example, many thousands of our compatriots from Venezuela coming into the country, and that provides some interesting challenges, both in terms of language, in the use of ADR, as well as, again, cultural differences. I think one of the things that we have to appreciate is that Caribbean societies are not necessarily homogeneous, but there are important cultural differences, and I think any mediator would have to have some sense of that when you're trying to assist parties to resolve disputes.
Thank you so very much, Millard. I wanted to ask two questions, but I'm looking at the time. But let me go for cost and time frame. Is there any measurable difference or impact with when compared to litigation of settling via ADR? When compared to litigation?
Well, just very briefly, what I would say is that many mediators are free to charge what they think is appropriate, depending on the nature of the dispute. Of course, you would have the more experienced mediators likely to have a higher fee structure and so on, and sometimes that mirrors what attorneys themselves may charge. But I would suggest that there is a level of flexibility there, and then there are significant savings of costs to potential litigants as well too. So, while I don't think we can necessarily cap what the fee of a mediator may be, I think very often they will take as their point of reference what you may see some of the fees emanating from, for example, the High Court.
Thank you. I think we've got minutes left. So the final question is, can you tell me more about the Chartered Institute of Arbitrators initiatives to promote ADR in
Yes, I think it's a body that was established quite a long time ago in the early part of the 20th century. And of course, the practice of arbitration was really designed to assist merchants or those engaging in commercial transactions to have somebody there who may be familiar with commercial practice and procedures. And out of those early days, back in the early 20th century, we've seen this body grow significantly so that it offers a range of training in not only mediation, of course, arbitration particularly, but other forms of dispute resolution, And I think expert determination, for example, is another form that can be useful. And what I'm seeing is that there's an increasing need for it, and I think the Chartered Institute has been offering several training courses, both in person and online. So, for example, we have an upcoming conference, in mid-October in Trinidad and Tobago, and hopefully that is going to bring together experts from across the field, not just locally, but regionally and internationally. And to that extent, I think that level of interaction and networking, I think is going to help to further promote the use of ADR within the Caribbean.
Oh, thank you so very much, my lord. I appreciate your insights and perspective and the learning you shared with us. And I believe that potential users would, of course, opt for ADR whenever the need arises. And of course, potential masses that would want to train to become a mediator or arbitrator would, of course, embrace all you have stated here and go for it. So thank you for coming on the show. This has been a masterclass. Bye. Bye. Cheers.
Thank you so much. It's truly been a pleasure. And I look forward to our